ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా, 8,000 మీకే వస్తాయి.
ఎస్ మ్యామ్, మేము కేవలం హాల్మార్క్ 916 గోల్డ్నే అమ్ముతాం. ఇంకా మీకు దొరికింది 100% ఎక్స్చేంజ్ వాల్యూ.
క్వాలిటీ, ఇది మలబార్ ప్రామిస్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్, 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్.
TVASIA Telugu ప్రేక్షకులందరికీ hello and welcome back to yet another fantastic episode of our talk show, The Experts. మనతో ఉన్నారు మన expert Rahul Reddy garu. Rahul garu, thank you so much for joining us again on this show this week.
Thank you for inviting Andy.
Thanks Rahul garu. And as usual, we have a lot of pressing topics, but I think EV Kochi, let's get started really quick with information about prevailing wages and matter for H-1B and Perm labor. They have increased. I know there have been a lot of changes in the past week. So I just quickly wanted to get on board and start to cover the details about that increase. Can you tell us a little more about that?
Well, one thing I want to object what you said to Nitya garu. You said it's going to be fantastic show. I disagree with it. It will be a worse show. One of the main reason is that we have a lot of bad news coming out. Especially with this Trump administration going around, he's just trying to burn as much as possible.
Hopefully our show will still be fantastic, Andy, because the information that people get from you might help.
I'm not sure.
Okay.
If I'm an audience, I would not like it.
Oh, but, my God.
Well,
okay.
they have to listen, and they have to listen. If they are in the immigrants, have to listen. One thing is that the Trump administration last week, what we said is that H-1B will be based on the quota. The quota will be based on the salary level. Whether it's going to be 4-level salary, it will be much better. You have a better chance of getting it. And then if it's a level 3 salary, it'll be you have a better chance. If you're level 2, there is absolutely very less chance. Level 1, no chance at all.
Okay.
Now, last week they did added one more regulation, which was stuck down by the court because of the technical issue, which was published in October. Because they published as an interim final regulation. They didn't give a chance for the people to comment on it.
Okay.
Now, after the regulation has been published, we were able to comment it, and now they released it as a final regulation. This regulation is going to go effective 60 days from now. According to this regulation, the prevailing wages have gone up, will go up.
Okay.
They'll become effective on July 1st. So all the prevailing wages will be going up by approximately around 30-35% at a minimum, and some cases maybe up to 50% at a minimum. So if we're filing an H-1B, for example, in Dallas area for $80,000, we may at minimum have to have $105,000 as a minimum salary. Otherwise, we will not be able to file a H-1B. That is one thing.
Okay.
That was released last Monday, and we are grappling with it. And then guess what? We have an advanced copy of a new regulation that will be published on Monday. This is going to be even more damaging.
Oh my God. Okay.
According to this regulations, which was actually published in October, the court struck it down. According to this regulation, if a person is placed at a third-party site, two people have to file an LCA. One employer and the other employer. Most probably, both of them have to file a H-1B application, though. We are not yet sure how they are going to determine. So that means that, let's say Accenture is placing an individual at AT&T. So Accenture has to file a H-1B. Accenture has to file a labor condition application with the Labor Department. For sure, we know that at this point of time, that even AT&T have to file an LCA, labor condition application, promising that they are going to abide by the regulations. They may even have to file another H-1B. That means that both companies have to file a H-1B. This is going to be very damaging. Approximately 60% of the entire jobs are for consulting companies like Accenture, TCS, and other companies. So most probably, if this regulations goes through, though, all these people have to go back to their home country because they're not going to file the H-1Bs anymore.
And this how would even the double H-1B even work, like as a process?
We yet don't know. They are going to come up with, the USCIS is going to come up with a plan how they are going to implement these regulations. It's just an advanced copy was released very late. So we haven't had digested it, and the USCIS has not commented anything on it. We have to yet see how this is going to work. We are praying right now to the new administration to block all these regulations and the executive orders that the Trump administration is issuing. So if they don't block, though, we will be in trouble. I mean, everybody will be in trouble. Most of the H-1Bs will be in trouble. Biden administration has indicated that he's going to block it, but is he going to block everything? Is he going to block some things? Is he going to block what is most important to us? Is he going to block ours? I mean, that's all we want. So we have to see if he's going to block or he's going to just ignore them and make us suffer. We have to see that.
Wow. Okay. Yeah. This is some pretty damaging news.
And Trump administration is not done as of today. He's
Boy.
going to be in power until 20th of January. So he has, what
true.
is today? 3 more days
17,
left there. Yeah, 3 more days left there. We don't know what else he can bring in. We don't know.
And even if this comes in as a regulation, what are the chances of being able to fight it in courts? Is this something that can even be fought in courts?
Last time when my Jonathan Watson is a good friend of me who fought this in the court. When he mainly argued that why do they have to put it as an interim regulations? When they publish regulations, they have to give a chance for the people to comment on it. The administration did not give any chance for us to comment on it. What was the necessary? What is it so emergency that you have to publish as an interim regulation? That was the main ground that he fought on, which he won. The issue right now is that's gone. I mean, technical grounds is gone because now they have given chance for us to comment on it. It's not interim regulations. It was published in October. It got struck down. Now they published again. So we had chance to comment and they have chance to listen to our comments. That's main argument that a lot of these IT surveillance, Jonathan Watson, and also I remember some trade associations, that main argument is gone. Now we have to rely on the side arguments. It's going to be tough if we are going to fight these things in the court. The best way would be probably to request Biden administration to take these regulations out.
And how can people push the Biden administration to do this at this point?
We have to lobby it. We have to request them to do it. We'll have to see in the first week, is he going to just automatically say X mark every regulation, every executive order that was passed in the past 2 months, and then look into which ones he want to pass it. That makes a very good sense. But if he's going to try to pick and choose, is our thing in the top priority? Maybe, maybe not. If our thing is not in the priority, then we may not be able to, this may become effective, and it's going to create a lot of problem for us.
I can imagine how disastrous it will be if
Yeah.
it does come into effect. But on that note, let's start, addressing some of our callers and viewers' concerns at this point. Rahul Garu, thank you so much for the,
Sure.
explanation of, what could possibly happen. All right, let's go on and take our caller. First caller for the day, please. Sir, area code 201, please press *6 to unmute your line. And in the meantime, let's take a YouTube question as well. This is from John Zachariah. He says he applied for a 485 around November 20th. And he's asking, when can I expect a receipt from USCIS?
They are issuing the receipt notices that were filed on October 27th and October 28th, especially in the Louisville, Texas address, which is Dallas, Texas, actually.
Right.
So to come to November, it may not take a month time because the applications that were being filed in the last week of October are humongous. I know that they have issued almost many of them that were received on October 27th, but not all of them. So it may take maybe 2 to 3 weeks for him to get a receipt notice.
Okay. All right. Thank you, sir. Sir, caller with area code 201. We're ready for you, sir. All right. Let's try going to our next caller, Andy. Hello. So area code 480. Hello. Okay. While we wait on this caller, let's take another question on YouTube, Monday. This is from Anand N. He says, Rahul sir, I got laid off from company A in June of 2020 after working there for 5 years. Hello?
Yeah, hi. I can stay on mute, sorry.
Hi, no problem, sir. Please go ahead with your question. We'll go back to the YouTube question later.
Okay, thanks. Thanks both Rahul and Nitya. So I was listening, obviously I was also following the couple of updates which Rahul shared, right? So my question is related to the downgrade, kind of relying more on the EAD now versus the way H-1B is going. So mine was filed on October 26th, the downgrade for adjustment of status, and still haven't received receipts.
Filed on October 26th. When did the immigration received it? What is the FedEx tracking tells you?
It's a good question. I'm assuming he told me overnight because I did not really ask the FedEx number and all to my lawyer. So I'm assuming probably 27th.
So either it's 27th, it could be 28th also. It could be 29th too. So they're still working on 27th receipt notices right now.
Okay. Now it just kind of worries me because, folks around me, it was fine as I was listening to you on your calls, right?
I'm tracking every single day. And based on all the things right now, I have nobody whose application was being received before October 27th. That is before, if it has been filed on or before October 26th, everybody received the receipt notice. This is my statement. In your case, you are October 27th. Yes, I told the same story last week also to you that it was October 26th. And it still is October 26th because believe me, there are a lot of applications filed on October 27th. So they are getting to it. So you should be getting it by next week. October 27th should be done.
And considering we have couple of days of off next week, it maybe even push further. It just kind of because of the inauguration thing and
inauguration has nothing to do with this one. Could be. You could be waiting for the next week also. Monday is a holiday for the immigration. Definitely, yeah. We don't know, but this is October 27th. Not everybody has been receipted yet.
So not to worry yet, right? The thing is, people around me have started receiving who filed later than me, but it just otherwise I was.
As I said to you, sorry, excuse me. As I said to you that we are tracking, and based on that, if your application has been received on October 26th, you should worry about it. If it is October 27th, you don't worry about it right now. Okay? That's all.
Okay, sure. Thanks.
Nothing your lawyer
can I squeeze it? Yeah, can I squeeze in one quick question, please?
Yeah.
So I was, this is like I wanted to ask this for a while, but because of this H-1B, the way things are going, right, I'm kind of looking forward to get all this EAD and stuff right before my visa expires next year, December. I mean, this year, December rather now, which is actually 2021. So in 2017, my visa was filed for extension. And in those times, it was taking very long time. It was new, right? The Trump administration stuff going on. And it took almost 7 months for no response to come. And then I converted it to premium, got an RFE, and I passed the 9 months. And it was beyond 240 days after my I-94 was expired. And after RFE, I got my visa was rejected. So the day it was rejected, after 2 or 3 days or 4 days, I left the country, and my lawyer filed a visa again, and it was approved for 3 years, and I entered United States back after going to consulate processing in India. So the only thing that worries me is this AOS application. How much of my time may be considered as out of status or illegal?
It is still less than 180 days under any circumstances you're speaking about. So you should be good.
Even if my I-94 was expired beyond
it's not the I-94 expired. We're counting the 240 days. After the 240 days. And we are counting when the denial came in, how long you stayed in the country. Either way, it's less than 180 days. You should not be that much worried about it.
Okay. Okay. Thanks for your answers. Thank you. Thank you so much, both of you. Thank you.
Thank you for calling in. All right, Rahul garu, while we take our next caller, let's just get through with this question from Anand N. He says he got laid off from company A in June of 2020 after working there for 5 years. And he said, I joined a small consulting company B in August. In August. And then on October 22nd, company A filed my EB3 downgrade, and I got a receipt. After getting EAD and an I-140 from company A, 6 months after EB3 downgrade in May 2021, can I use the 485J and move to company C in another state? If so, should I work again with company A anytime in my future? My current company B is small, so if they lay me off, what are my options? Can I use my EAD, which I'm expecting by next month, and also the I-140 by May? And if there's any chance my I-140 gets rejected because of the fact that it was filed by company
A? His plan to move out of the company after the I-140 is approved and after 6 months, and his plan to move after that particular period that he's speaking about to company C is relatively safe under the current conditions that he is in. Is it guaranteed? There are some risks involved, slight risks involved in it. I would give it a 5% risk for him, that the company is small, that he left the company and that he never going to join company A. There are some 5% risk involved in it. But as such, based on what he's telling, his plan seems to be good. In the 5-year him, I would plan the same way like he did it. The fact that he's going to move to a different state after the dates that he is speaking about, after the I-140 is approved in 180 days, it won't matter at all. Whether it's the same state or a different state, it will not matter whatsoever at all. The new company needs to file a 485J supplement. So he is relatively safe.
Got it. Okay. All right. Thank you, Rahul garu. Let's take our next caller, Andy. Sir, area code 248. We're ready for you.
Sir, hello Rahul sir, good evening. This is RK. Sir, actually, can you able to hear me?
Yes.
Yes, I can, RK.
Okay. Sir, actually, my priority date was, earlier I was an EB2. Priority date was Jan 2012. And later, actually, I applied on EB1 and recently, like 7-8 months ago. And EB1 was approved. And I applied, approved in June, and I applied for 485, I-131, 765 on July 2nd. And within 4 weeks, I got the fingerprinting done. Within another 2-3 weeks, the medicals also, they asked for the medicals. So both are done. So since from August 18th, 2020, it's almost 4.5 months. I have not seen any update on the website. Either it is 485, 131 or 765. Is there anything else that I can to speed up the process, or
No.
I mean, I don't know what is going on actually, So
Yeah,
is there any way that I can get to know?
Right now, they are taking approximately 10 months to get an EAD in advance parole. Now, I know some officers are approving only in 2 months, but in general though, 10 months is a normal time. You've applied in July, so EAD in advance parole is going in the normal pace. When it comes to the 485 application though, according to the online status, right now they are showing that it's taking approximately 4 years to adjudicate the applications. So there is not much you can do at this point of time. You're relatively safe because your I-140 with EB1 has been approved. Normally, it is a risk to get an I-140 approved under EB1. It may not be risk for getting an EB2 and EB3. EB1 is always risky. You got through that main hurdle that's there. So you're fine. There is not much you can do. Just hold on. That's about it. Okay?
Okay, sir. And so nowadays EAD is taking, you said, up to 10 months, is it? So
yeah,
on the
that
website
is right.
Yeah,
that is right.
Okay. Sir, once we get an EAD and advance payroll, can we travel to India? I mean, is it
since
safe
your I-1
to do it? Both, I've seen both the states.
Since your I-140 is approved, if I were you, I would travel based on the advance parole that gets approved. I will travel. I will not hesitate to travel on the advance parole.
Okay. Sir, the other thing is, I have seen somewhere, I've read somewhere that say if the USCIS asks for the RFE, so I think they should respond in 80 days or 90 days after they receive the the documents. Is that true, or it is just something?
It depends on. Sometimes they may issue an RFE within 30 days, which because of the COVID conditions, they extended it by 60 days for every deadline.
Okay, but my question is, I have submitted, my question is, they have asked the RFE, I submitted in August, so since then it is almost 4.5 months. So is it something they should respond, after receiving the RFE, they should respond it within 90 days, there is something like that? Or
No, there is nothing like that. As long as if your online status says that your RFE has been received by the immigration, especially the medical thing, they won't respond to it. The response to that is only approval of the green card, which is going to be a long time for you.
Okay. So, but what are the chances that you can think that it can approve without interview? Is there any possibilities?
There are possibilities, always possibility. Is there a possible I can get $235 million next week in the lottery? Yes, it is possible. To tell you, so that's the reason I want people to ask what are the probabilities, not possibilities. Mostly everything is possible. If it's science possible, it's possible. So the probabilities are about 10% for you. I would go up to 20% because your medical RFE came in. Up to 20% for you to get a green card without interview.
Okay. Thank you very much. Appreciate it.
Thank you.
All right. Thank you, sir. Thank you for calling in. And then while we move on to our next caller, Randy, let's take a question on YouTube as well. This is from Raj. He says, married to the 485. He's the primary applicant on EB2. He's on EAD and completed more than 180 days after the receipt. If I lose the job now, what is my status and what other options to remain in the country and work? Or do I need to go back home? And based on the above, if 1 month on EAD is remaining, is a job needed to renew the EAD?
Good questions.
Rahul, 1 second. Area code 647. Can you put your TV on mute, please, sir? Thank you.
It's been more than 180 days he filed the 483 application. I'm assuming that he's not a downgrade application, so his I-140 is already approved. So if he loses a job, he doesn't have to leave the country. He can find another employer. They need to file a 485J supplement. It's a very simple process.
Okay.
With regards to if EAD is expiring though, they are not going to ask employer to file an EAD. he can file a EAD by himself. And the good part about the EAD extension, the good part about...
Sorry, Andy. Hello, sir. Okay, can you please put yourself on mute? *6, Andy, to mute and unmute your line, sir. Thank you.
The good part about this guy is that if he can file a EAD, he doesn't need any employer to file an EAD. Once he files the EAD extension, even if the EAD expires, he can work up to 180 days after the EAD expires. This is only for when you file the EAD extension in the adjustment of status employment based, not for other things though, not for H4 EAD, not for the initial filing the EAD application. This guy, while the EAD is pending, he can work. So all he needs to do is that if he fears that his job is going to be he's going to be losing the job, all he needs to do is that find another employer, have them file a 485J supplement. It's 10 times easier than filing an H-1B to file a 485J supplement.
Okay. All right. Thank you. All right. Let's go to our caller, Andy. Sir, area code 647. We're ready for you now. Please press *6 to unmute your line. Hello, sir.
Hello. Actually, my I-40 approve అయిందండి. I-40 approve 4 years, 5 years అయింది యాక్చువల్గా. సారీ చాలా ఏళ్ళు అయింది. నేను కెనడా మూవ్ అయిపోయాను. కెనడా మూవ్ అయిపోయి 4 years అయింది. సిటిజన్షిప్ అప్లై చేశాను. సో సిటిజన్షిప్ అప్లై చేసి కూడా 1 year అయింది. బికాస్ ఆఫ్ కోవిడ్ ఐ థింక్ ఇట్స్ టేకింగ్ టైమ్ టు గెట్ సిటిజన్షిప్. 3-4 months లో సిటిజన్షిప్ రావచ్చు. బట్ ఐఎమ్ ట్రైంగ్ టు అప్లై ఫర్ అన్ H-1B అగైన్ విత్ ద సేమ్ ఎంప్లాయర్ హూ డిడ్ మై I-40. సో ఒకటి క్యాప్ ఎగ్జామ్ నాకు H-1 కూడా మళ్ళీ చేస్తే, ఇంకోటి ఏంటంటే సిటిజన్షిప్ ఈ మధ్యలో సిటిజన్షిప్ మారితే మన ప్రాబ్లం వస్తుందా? ఎందుకంటే కంగారు పడతాను, ఎందుకంటే ఈ వేజ్ లోన్స్ మారుతున్నాయి అవన్నీ కదా. సో ఈ జూలై కల్లా నేను H-1 చేసుకుందాం అనుకుంటున్నాను. అది
ఫస్ట్ థింగ్ ఇస్
చెప్పండి సార్.
You are not subject to cap for your life.
Okay.
Second is that what you said is that if you change the citizenship while the I-140 has been approved, will it cause any problem in you getting the H-1B or eventually getting a green card? Let me tell you the answer. No, it will not cause any problem whatsoever at all.
So H-1 కూడా ప్రాబ్లం ఉండదు నాకు? H-1 కూడా ప్రాబ్లం ఉండదు?
No. Because you change the citizenship, will it cause any problem for the H-1B? No, it will not.
సో ఎందుకంటే జూలై ముందు అప్లై చేద్దాం అనుకుంటా, అంటే ప్రివైలింగ్ వేజ్ కదా.
That is right. I mean, you can apply before July. Nothing wrong with it.
ఓకే, థ్యాంక్ యూ అండి. అది ఒకటే మళ్ళీ నేను స్టాంపింగ్ వెళ్ళక్కలే కదా, ఎందుకంటే అప్పుడు ఒకవేళ కెనడా ముందే వస్తే H-1 అప్లై చేశాక స్టాంపింగ్ వెళ్ళక్కలే కదా.
There are exceptions available for Kenyan citizens. There are exceptions available for Kenyan citizens for not getting the stamping. Okay?
Okay.
Okay.
Okay, thank you.
Thank you, sir. Thank you for calling.
Thank you.
All right. Let's go to our next caller, Andy. But in the meantime, we have a question from 𝗧𝗓𝗪 𝗪𝗧𝗛. He says, can you please provide details on criteria for applying for 485? Can I apply immediately after I-140 approval? Why should we submit FOI request with USCIS? Can you please tell the scenario in which I need to do that?
Mohan, you need to have the priority date to be current. There is something called final action date and there is something called filing dates. Sometimes the immigration goes with the final action date, sometimes they go with the filing dates. So you need to be aware of what a priority date is. The priority date is there are a lot of people who are ahead in the line right now, especially people waiting from 2015 to right now. If you have recently filed an I-140, there are a lot of people. I'm assuming that you are an Indian national, and a lot of people are ahead of line. So if a lot of people are ahead of line, you can't just file the adjustment of status. Your priority date has to become current for you to file. The adjustment of status. Until that, you cannot. With regards to the freedom of information, mostly what we recommend people to file freedom of information when you have an I-140 is that to get a file of what I-140 application has. The reason is that when you move, the priority date might take 10, 20 years, 50 years, who knows? It may take a long time for you to get the priority date. So for that reason, we recommend people to get a copy of the petition. You can go to US, type in USCIS FOIA. You can file it online. You'll get a copy of the I-140 petition. It's always good to keep it. It's not necessary. It's recommended that you keep a copy of that.
All right. Thank you, Rahul Garu. Let's go to a caller, Andy. Hello, sir. Area code 917. Please press *6 to unmute your line, sir. So area code 917. Please press *6 to unmute your phone line.
Hello.
Hello.
Hi, Rahul Garu.
Hi, Andy. Cheppandi, please.
Cheppandi, sir.
Thank you, Nitya Garu, and thank you, Rahul Garu. Thank helping for the community. I always watching your videos in TVASIA and YouTube. Myself, Jeevan Reddy. My priority date is in December 2016. My L1 extension got denied in July 2019. After that, I moved as my wife's dependent as an H4. Then started my master's from January 2020. Applied change of status to F1, currently in progress from 8 months. Once I got an F1 approval, planning to work through CPT, what is the best option to go back to my previous employer, that is I-140 approved, or I can look for a new employer? Which will be the best option considering priority dates can be moved in this year, October?
Did your wife file? When is your H4 expiring?
October 2022.
Did your wife file a labor and I-140 application?
Its prevailing wage determination is in progress.
So she's on the way to file those things. Which university did you file for F1 visa though?
Train University.
What is it?
Train University, Indianapolis.
Okay. Any university that gives the CPT on the day one you join the college, we consider that college or university as a fraudulent university. We do not recommend people to continue working on the CPTs. We have had 2 universities that were being, the university presidents or the deans are in jail. One is Tri-Valley University, one is Silicon Valley University. There are 2 other universities that are sting operation. The sting operation day 1 CPT university are University of Northern New Jersey. The second university is Farmington University. So this is all indication that any university that is giving a day 1 CPT is an illegal university. It's simply like this. Do you think so the police officer is going to pose as selling a Coca-Cola bottle and arrest us because we bought a Coca-Cola? No, they won't do it. But they may pose and sell some illegal things so that they can trap us. So that tells us that day 1 CPT is a trap. Don't fall into it. You may want to consider very seriously with regards to getting your wife's I-140 approval and getting an EAD. That would be the best way to do it. The second thing is that getting to F1 and after you complete the master's degree, getting to the H-1B is better, but we do not recommend day 1 CPTs.
Sure, sir. Thank you so much.
Thank you, sir.
Thank you, sir. Thank you for calling.
Nityagar, what happens is that it is becoming an easy available thing.
Yes.
Just like buying a Coke, getting a CPT is easy, but CPT is not for the purpose of the work permit. It's only curricular practical training. And these universities have no admission criteria. Even I can apply for a master's in computer science, even though I don't have a computer science degree. And there is classes starts anytime.
Right.
Anytime. These are all indications of fraud. Please stay away, guys.
Rahul, I remember we did an episode on this also about the day 1 CPT colleges and the ramifications that a lot of people had because they were a part of it.
Sure.
So yeah, I think, it's a fair point that it's coming up again now. Thank you for reminding everyone to stay away from them. All right, Rahul, on to our next caller, Andy. Hello, sir. Area code 201.
Hello. Hi, can you hear me?
Hi, yeah, we can hear you.
Hi. Hi, Rahul. I'm Nitya. This is Pavan. So my question is, just around October, when the dates moved, So currently I work at a client as a consultant, and I have my EP2 priority date in 2010. So my current company applied a concurrent filing. So I mean around October 28th is when I think the application was sent to the logbook. So the thing is, I didn't get the receipt yet, notice yet. That's the first thing. And then, so I don't know how long does it take for the concurrent I-140, which is fine.
They are working on October 27th as of this week, though. Maybe next week they'll get to October 28th. Even last week also, they're still working on October 27th.
So my question on the same is, like, since my company has filed this concurrent I-140, what does that mean for my overall adjustment of status application?
What do you mean overall? Once your I-140 is approved, you're Tom, Dick, and Harry.
Okay. So, I mean, what I wanted to understand was, like, only after my I-140 gets approved is when will I get the 485, the EAD or something?
No. EAD will be issued irrespective of whether I-140 has been approved or not. EAD will be issued irrespective of your biometrics or not. EAD will be assured irrespective of whether you have submitted the medicals or not. But your green card will not be approved until you get the biometrics and your I-140 has been approved.
Okay, sure. And another question on this context is, like, since if in case, like, I want to move out to a new company, keeping in mind that, like,
first thing is that your I-140 must be approved. Your adjustment of status must be pending for at least 180 days.
80 days.
The third thing is that when you move to a different company, the new company has to file 485J supplement. That means that they are going to tell the USCIS, look, we are going to take care of the green card. It's not going to be a company. It's going to be us. And the job is in the similar lines. It doesn't have to be same. Just have to be same profession. If you are in a software profession, if it's a software profession, you're good.
Sure. So one thing in the same discussion is, since my application was sent on October 28th, my receipt notice
it is
would be
not when you received. It is not when you receive the receipt notice. It is when the immigration received your application, the 180 days comes. When you get a receipt notice, on your receipt notice, there will be a column on the day this application has been received. On the day the notice has been issued and the day the application has been received. It is the day your application has been received, that's when you start counting 180 days. But I will also recommend one other thing. Do the premium processing of the I-140, okay?
Sure. As whenever I receive the I-140 notice, then I can initiate that. Sure. Thank you, Rahul. Yeah, I think that should be all. Thank you so much.
Thank you, sir. Thank you for calling in. Rahul Garu, before we take our next caller, there's a question on YouTube from Balakrishna. He says H-1B expired on 03 of 2020 in, I guess, March. Extension approved till Jan of 2023. Can I use advance parole for a vacation trip to India, re-enter using advance parole and continue in H-1B? Employer says yes, please confirm.
He can go on advance parole, but he would be considered to be married to this application. What we strongly recommend people is that don't get married to this application, at least if you're in the downgrade application, until your I-140 is approved. Don't wait until I-140 is approved. But technically he would be considered to be married to the adjustment of status application. We have covered the marriage to the application process somewhere in October of 2020. We have covered it. What is marriage to the, so please go back to TVASIA Immigration South, TVASIA Immigration in October, and you will have what is marriage to the adjustment of status means. Yeah, he will not be able to use one H-1B once he comes on advance parole.
So it's one or the other, right?
Yeah, it's this one or that one.
All right, thank you, Rahul Garu. All right, let's go to our next caller, Andy. Sir, area code 918, we're ready for you now.
Hello, sir. Can you hear me?
We can hear you,
yes,
sir.
Go ahead.
Okay.
Sir, my case is like this. I've been rolled off my project this Friday, and I have a I-94 for 2 more years, and I've applied for EB2 downgrade in October and waiting. So my 2 questions are: so if I get, I've been working remote since past March. So if I'm about to get 2 different remote projects, so how does the amendment thing work? I'm still staying in the same location, but the clients will be in different states.
Wait. You are right now. Did you got laid off right now?
Yes. I mean, I'm with a employer vendor client model. I mean,
so you got laid
my
off.
client project.
So you got laid off. You got laid off with
from the project.
From your end client, not with your company.
Yeah, not with the company. Just the project has ended. Project has ended. So I'm in the process of finding another project. So right now I have two discussions going on, but two of the projects are not in the state I reside in. They're in different states. So should I file an amendment or?
But they're all remote jobs.
It's all remote.
Right? So you're still
both of them are remote jobs.
So you're still sitting at the same location, same MSA of what your original H1.
Yeah.
Same location. What you originally filed H1B.
Yes.
You do not.
Yes.
Since you're working in the similar profession, you do not have to file any amendments whatsoever at all. And when it
I don't remember whether they filed my home address as the location of work earlier.
Is it within the same MSA as your end client location?
Yeah, within.
Then they don't have to list it. Then they don't. Even if it's not listed, you're fine. You don't have to still file. You do not have to file an amendment. And you can take up the 2 end client projects at the same time. No problem with it.
Perfect.
Let me repeat again.
Perfect, sir.
If your employer is willing to get you 2 projects, 2 different end clients, and you're working on it, you're a professional worker, you can work for a long time. 40 hours is not limited for professional workers. I work more hours. So there is nothing wrong in having 2 end client projects at the same time. And you do not have to file any amendments whatsoever at all under the conditions you are in right now.
Perfect. Perfect, sir.
Thank you.
Sir, next question is, since the downgrade thing has been done on October, I heard some of your calls, people are reporting that they're getting EADs. Is it because of the service center or is it because of downgrade?
We have had, there are some people who got the EADs. That is right. Especially those people who filed in the October 1st week, they did get, some of the people got EADs. It's not all because it depends on the officer. Some of the officers are very quick. Some of the officers are not quick. So there is nothing you can do if you don't get it. You just have to wait. Okay. But yes, there are some people who are getting it.
Okay. Thank you so much. That's all I have.
Thank you so much for calling in. All right, Rahul, while we take our next caller, Andy, let's get on to a YouTube question. This is from Pavani Papala. She says, working as a senior analyst, Perm certificate is under processing. If getting promoted to manager, roles may change. Will it affect the Perm? If yes, what's my best option?
Pavani, the natural increase in the position should not affect your Perm or I-140 or adjustment of status. If it's a unnatural move, for example, if you move from a 614, just hold on for a minute, sir, okay? Pavani, if you move from a senior software analyst position to a mechanical engineer or a lawyer or a doctor, that doesn't look to be a natural increase in the position. It's a different line. In your case, you've just moved up to a one higher level within the same hierarchy, within the same profession. It should not affect. That is my opinion. But if the employer feels it, no, it is a completely different profession, you are a different, then it's a different issue. Normally employers don't, but if some employer, according to me though, she doesn't need anything, everything is fine, should go through as it is.
Okay, thank you, Rahul Garu. Let's get to our caller, Andy. Sir, area code 614, we're ready for you now.
Thank you.
Thank you, Nithya Garu, and thank you, Lawyer Garu, so for your time and opportunity. Every time we see your video, it makes us learn a lot of stuff of the immigration process. So the question here is, currently, I have my H-1B is approved in 2020, and my employer started processing Perm for me in this January. So, and basic question is, sir, if I'm stamping, can I go to Canada because I already have the Canada visitor visa, or shall I, the best bet is to go back to India?
You could go to, you have a master's degree in USA, right? So you could.
Correct, I do.
Is right? Yeah. You could go to either Canada or India, though. There is nothing, particular about going to Canada or India. Both have the same chances, but if you feel Canada is safer, nothing wrong with it. You can go to Canada. However, right now, there are a lot of limitations with regards to the appointment, whether it's here in Canada or it's in India. There's a lot of limitations. Even if you make an appointment, by the time you go, they're canceling the appointments. Be careful on those things. Don't rely on the appointments completely right now.
Okay. And currently, sir, looking at looking at other Facebook groups and getting in touch with a lot of Telegram groups. So what I see is basically the appointments are getting canceled only for Feb and March, but everything seems to be resuming in April. So still
wait. The September, October got cancelled. November, December got cancelled. January, February got cancelled. So now you're telling April and May will be there for sure. No, April and May are not getting cancelled right now. They'll get cancelled. They may get cancelled in March or April. You see my point?
Okay. Yes, I do. Yeah, of course.
So I don't want people to make an appointment and travel there, and then the appointment get cancelled. Boom, you lose the job, you lose the H-1B.
All right. Okay. So it's the same order. Go Canada or go India. It's the same thing.
The same thing. Same thing with both.
Okay.
Thanks.
So currently, so one more quick question. So, currently looking at the perm weight or perm weightage, or how much is the wait time for the perm, sir? I mean, like once we apply the perm and the job, not that
perm used to be 4 to 5 months, and nowadays it's taking about almost like 8 months for perm.
Okay.
Unfortunately, the time has gone up. But it's good that you just got the H-1B. It's good that you're working on the green card. Not many of the people take care of it as soon as they get the H-1B. They wait until a couple of years. You are definitely are in a right path of, as soon as you got the H-1B, you start working on the green card. That's very good.
Okay. Thank you so much, sir. And also thank you once again. Thanks a ton.
Thank you, sir. Thank you for calling.
It's because we can even take the credit, Nithya Garu, because he's our audience. He's very active.
Yeah.
Getting the green card faster.
I know. That's awesome. All right, Rahul Garu, while we take our next, wait on for our next caller, we'll just take one YouTube question really quick. This is from Soma. She says, thanks for your support. My question is, even if the child ages out when the priority date becomes current, is the I-140 processing time considered?
Yes. The I-140 processing time will be taken out from the age of the kid. So if the I-140, especially the downgrade application, is pending for 1 year, the kid is not going to become 21 until he reaches 22. But there is another caveat here. If people are trying to manage the H-4 and adjustment of status, and particularly when the kid's age is about to be kicked out, we strongly recommend that they don't get married to this application, because when they get kicked out of the adjustment of status application, they cannot move to the F1 visa. So when it comes to the H-4 though, they get kicked out of H-4 and they would be automatically married to the adjustment of status if they don't have an F1 visa.
Okay, that makes sense.
So they need to be very careful on both the things. One is age will be deducted only for the adjustment of status purposes, not for the H-4 purposes.
Okay. Thank you, Rahul Garu, for that clarification. On that note, let's go to our next caller, Reddy. So area code 405, please press *6 to unmute your line. Area code 405, sir. Hello?
Hello, Nitya and Rahul. Can you guys hear me?
Yes,
we can.
Please go ahead.
Yeah. First of all, thank you for everything you guys do for the community. My question is, I've applied for 485 and adjustment of status in October.
Mm-hmm.
In November, I got my new passport from the Indian consulate. My I-94 is valid until April of 2021, so I got 3 more months. And then my current H1 is valid until next year, May of 2022. Since I can't travel outside the country to...
Okay.
Go ahead.
So I got the point. Let me understand. Your I-94 is expiring in April 2021, but your passport visa is expiring in May of 2022. And you filed the adjustment status. Did you receive the receipt notice?
I haven't received the receipt notice yet.
Keep going.
So since I can't travel outside the country for my lawyer during the 485 application is in process, I tried at the airport CBP office and they didn't extend my I-94. So my lawyer is suggesting that I should
file an extension. Actually, you could travel though right now. The only thing that will be denied, I would still wait until the receipt notice comes in, which most probably will come in a week or 10 days time, is all right? We do expect that to come. As far as the traveling is concerned, you can travel. The only thing is that your advance parole application will be denied. Even if it's approved, you should not use the advance parole. The only thing is that you can go to Mexico, have a margarita and come back, and after you get the receipt notice, but file an advance parole again. Simple.
Okay.
And your EAD will be adjudicated. Your EAD will not be denied. It's only advance parole that will be denied.
Which I can file again later too.
Right. You can file. It's not negative. Oh, your advance parole got denied. Will it have any problem? No, it will not have any problem. You're fine.
Okay, because my lawyer talked to my company and they suggested that I should not travel, and they're asking that we should go and file for H1 extension. So I'm not sure how can they file H1 extension when I still have a year and a half left on the existing H1.
They can file an extension if they want to, because it's the April 2021 that counts, not May of 2022. They can file an extension. Absolutely nothing wrong. But I will, nothing wrong with it. They can do that too. I would go have a margarita and come back. But if your lawyer chooses the other way, that's up to him. Nothing wrong with it.
Okay.
They can file an extension right now.
Okay. That's all I had. Thank you very much, sir.
Thank you.
Thank you, sir. Thank you for calling. All right. Rahul, let's take our next question while we are getting our next caller on board. This is from Ramesh Appala. He says H4 extension applied here in the month of July, but due to family urgency, they went to India and getting visa stamp over there. They're still in India, and now I got the biometric appointment. How shall we respond now?
Biometrics appointments for the H4, it will be denied if they don't come in. Why? Since they are stuck in India, they don't have a visa. That's what I'm thinking about. Both of them can come. They don't need a H4 approval. They don't need a H4.
So area code 678, please press *6 to mute your line, sir. Leda, please mute the TV so that we can just finish up with this question. Thank you, sir.
So since she doesn't need a H4 approval to get the H4 stamping.
Mm-hmm.
So when this guy gets the H-1B approval, he can go and get the stamping. She doesn't need H-4 approval to get the H-4 stamping in India.
Okay.
She can use the H-1 approval of the husband or the spouse and get the H-4 approval. She does not need the H-4 approval here.
And how does the biometrics tie into that then?
Since they filed H-1 and H-4, USC has issued a biometric notice to get the H-4 approval in United States. Since the biometrics, she is not going to go to biometrics, the H-4 will be denied, but it will not have any negative impact. She's still getting the H-4 approval in India, so she will not have any problem. She is fine.
Gotcha. Okay. Thanks, Andy. So area code 678, we're ready for you now.
Hi.
Hi, sir.
Hi,
Please.
this is Ravi. So thank you very much, Rahul garu and Nitya. And one question అండి మాకు ఒకటి ఏంటంటే మీరు బిఫోర్ లాస్ట్ వీక్ మీ వీడియో చూసినప్పుడు మీరు వి స్టాక్స్ క్యాన్ బి స్టాక్స్ కొనకూడదని మీరు సజెస్ట్ చేశారు. సో చేసినప్పుడు ఎలా అంటే ఇప్పుడు మాకు బై మిస్టేక్లీ అవి కొనేసి అంటే మాకు ఐడియా లేదు దాని గురించి. సో బై మిస్టేక్
right now sell it off, okay? That's my advice. Okay. And keep watching if there is anything that pops up. There is nothing you can do right now. What is done cannot be undone right now.
So any future lo any problem gani mana ante green card or citizenship
at this point of time they are only creating problems for the people who are using the weed, okay? They are not creating any problem for the people who purchase this weed stock. Only the people who are using the weed, they are creating a problem. So we'll have to see if there is any updates on that. I will let you know. I just want to be cautious because I don't know how the governments are going to act on this one. That's the reason I want to be very cautious and tell everybody not to involve in the weed stocks.
Oh, okay. Thank you, sir. Thank you very much. That's it. Yeah. Thank you very much.
Sir. Thank you for calling in. All right, let's go to our next question. This is from Suresh L. Says, good evening, Rahul. I have a question regarding LLC. I'm on an H-1B and applied for an AOS in October. Can I be a partner in an LLC with rental income? Can we also buy farmlands and do farming?
If you are a passive investor in the real estate that you're speaking about, like the farmland and also in the house, there are two partners. One is the passive and active investor. So if you're a passive and active partner, if you have a passive partner, that means your role is nothing other than investing the money and taking the profit, especially only if it's a real estate, I would be okay to do with it. Now, the reason I strictly stick to real estate is that there are people who become partners in a restaurant and then the weekend they go and sit down there and they go and look into the inventory. That's not allowed though. But if it's a real estate investment as a passive investment, you're going to buy the farmlands or lands, nothing wrong with it. You're fine.
Okay, fair enough. Thank you, Andy. All right, let's go to our next caller, Rahul garu. Sir, area code 516. Please press *6 to unmute your line, sir. We're ready for you. Just give him a second. So area code 516. Hello? Sir, *6 to unmute your line. Okay, let's take our next...
Hello, can you hear me?
Yeah, we can hear you now, sir.
Yes.
Hello, Rahul garu. Hello, Nitya garu.
No, sir.
Yeah, I have a question, Rahul garu. My H-1B was approved on September 2020 under counselor, so I have I-797B.
Why was it approved in consular processing?
Because I was on CPT. It was not a day one CPT, but it was I took CPT for more than a year.
Okay.
Okay. So the consulates in India, they have tweeted that they are accommodating limited number of H-1B regular appointments. And on the State Department website, they say that you are exempted from proclamation if you are in US when the initial proclamation was signed. So does that mean I fall under exemption or am I still under?
Since you are here in United States, you are exempted from the proclamation. Yes.
So even if I'm on F1.
That is right. That is right.
Okay. So regardless of visa, even if you are in US before June 24. Right.
Yeah. When they initially issued the proclamation and then later on they changed the proclamation to include the people, everybody who is in United States.
Okay, so if I can legally go if an appointment is available and they are honoring it, I can legally go and have my interview.
That is right. That is right, sir. That is right, sir.
Okay, thank you so much, sir. Thank you so much. Thank you, Nitya. Thank you, Rahul.
Thank you for calling in. All right, Rahul garu, while we take our next caller, let's quickly address a question on YouTube. This is from 𝗧𝗔𝗟𝗞 𝗦𝗪. He says, what are your views on the new rule DOL is talking about that the end client should file the LCA? And I think we talked about it. I know it's hard to predict how it plays down down the line, but would like to know your perspective.
I would say that we will do a better presentation because I want to have more debate with the other lawyers on it. I will have a debate on YouTube on Tuesday, but next week we'll be a little bit more prepared with it. The reason is that the Department of Labor proclamation came in early. Then we got the advanced copy of the regulations of the employer-employee relationship, how they are going to interact. It seems most probably that both companies have to file an LCA. We still need to see if both companies have to file an H-1B. One thing is for sure, no matter which way I interpret this one, the consulting companies, if this regulation stands as it is, the people who are working with consulting companies will not be able to extend the H-1Bs. Yeah. They will not be able to file the H-1Bs. They will not be able to file a transfer of applications. So practically the consulting business is going to be dead if these regulations are going to go through. Yeah. Now it's not only applicable to the computer consulting companies. It's also applicable to the doctors. I'll tell you an example of it. In most of the states, though, hospitals cannot employ doctors. Period.
Okay.
It's in Texas, hospitals cannot employ doctors. So doctors always are employed by outside agencies. So I don't know how they would file an LCA. I don't know how the hospitals will be able to file a H-1B. They can't. I mean, the law says they can't. I mean, in some states they're allowed to work with that. In some states they're allowed to work. In most of the states they're not. For example, in Texas, the hospitals cannot employ doctors. Wow. So how are they going to file the H-1B when there is a consulting company that is filing an H-1B? The state law says they cannot. Now the federal law says you have to. So all these doctors who are on H-1B should have to, especially working in the hospitals, will have to be kicked out. So there will be a lot of repercussions that will go on with these regulations and the interpretation of the DOL. And as you rightfully so asked, the Department of Labor interpretation is based on the regulations, the advanced copy of the regulations that we received it on Friday.
Okay.
So we are hoping Biden is going to stop. If Biden is not going to stop, then I would recommend all the people who are on H-1B, especially working for the consulting companies, either you move to the end clients or you lose the job.
Yeah, I think they're trying to force everybody's hand in terms of doing this.
That's what Trump is trying to burn everything before he goes.
And Rahul Garu, before you mentioned this, we had no idea about, these hospitals not being able to employ doctors and stuff, because a lot of them are mainly in the tech line, so they do not have any idea about, such regulations as well.
Right.
And so it's at least good to hear and understand how else this might impact other people who are on H-1B.
Sure.
Not just the tech industry.
Yeah.
But on that note, let's go to our next caller, Rahul Garu. Sir, area code 813, we're ready for you now.
Hi, Rahul Garu. Hi, Nithya Garu.
Hi, sir.
This is Krishna. My employer has started my GC process. My PWD is approved on Jan 7th, 2020, and recruitment is in process. And my employer said they will file my perm around April mid to by end of April 2020. And the new rule has come, right? Like the DOL wages rule. Will it going to affect my GC process? No. Because my max out date is 2020 Feb.
You're good right now. Based on the study of the regulations that I see, it is becoming effective on July 1st, and your application is getting filed in April, so you are good.
Okay. Thank you, sir. Yeah, that's the question I had.
Okay. Thank you, sir. Thank you for calling in. Rahul Garu, while we take our next caller, Andy, there's a question on YouTube. This is from Pinnacle Power.
On the study of
sir, can you please mute the channel? So, 409. Oh, ma'am. All right.
Let's go with
so this question is, it says, can an H-1B person start and run a startup in India while living in the US as a side hustle? Is it allowed?
No. People need to have work permit in USA to do any work. The governments at this point of time do not recognize cyberspace as a space. I use the bad word. It's not a bad word. It's a part of the body part. It is where your butt sits. You must have the employment authorization. If you're working in the Mars, if you're working in India, if you're working in Moon, it doesn't matter. Where is your butt sitting at? If your butt is sitting in USA, do you have a work permit for it? Since you do not have a work permit to work for an Indian company here, since your current company did not authorize you to work for that company, you are not allowed to work for Indian company while sitting in United States.
Okay, good to know. All right, on that note, let's go to our next caller, Andy. Area code 409, we're ready for you. Please press *6 to unmute your line.
Hello.
Hello. Yes, ma'am.
Yes.
Hello, Nithya Garu and Rahul Garu. I have one question, please. My I-140 is approved. Right now I'm in India, but after approval, after a couple of weeks, the status on USCIS online status is showing as case was sent to the Department of State. So what does it mean? And right now I'm not on the job.
Where are you right now?
Right now I'm in India. After coming to India, my I-140 is approved and Perm also approved after coming to India because my max out date is over by March.
This is a H-1B that is telling it has been sent to Department of State, is right? Which one is telling Department of State?
I-140 state.
Okay. So your I-140 is approved. You are in India. It has been sent to the Department of State. That is a right move. Nothing wrong with it. Because since you're not in the country, your lawyer might have put it as if that it's a counselor processing. So that is a right move. Your lawyer did it. That is a right move. The USCIS did it. That is exactly what is supposed to happen. And this is very good for you.
Oh, awesome. So following question, sir, please. What should I do now, right now? Because I'm not having the project right now, neither India or US right now. So I'm searching for a project. So what could be the best possibility to take the steps?
Since your I-140 is approved right now, I'm assuming that you were here in the United States on H-1B for a period of time and you left the country after your six-year limit expired. Is that what it is? Almost?
Yes, please. Yes, it's done already.
Once you get the project, you can file a H-1B. You can come into United States. Since your I-140 has been approved and you were previously counted towards the H-1B number, you do not have to be counted towards the H-1B number. Get the project, come into United States on H-1B and start working, period. That's it.
Irrespective of the pay, salaries and all, as per the new rules and all. Right?
Well, you will have to go with the new rules and regulations as they come and become effective. There's nothing, we don't know when and how it's going to be effective. Because as I said to you, we are expecting Biden administration to block it. If it does not block it, most of these things are becoming effective. Most of these becoming, for you though, they're becoming effective on July 1st. So if you can get a job before file H-1B, before July 1st, you will be able to come into the United States.
Okay, awesome. And quick question, please, sir. Am I eligible for the Dropbox option, waiver of interview?
When because was your previous H-1B expired? Visa.
The last one was last month. Last year, March 2nd, 2020.
Was your H-1B visa previously stamped in India?
Yes, please. But with other employer?
Doesn't matter. I didn't ask you that question. You are eligible for Dropbox.
Awesome. Thank you so much.
Thank you, ma'am.
Thank you. Thank you so much.
Yeah, I'm done. Thank
you. All right, Rahul, we have time for one question on YouTube, and this is from Ramesh Kadamaneni. Says, Rahul, so we filed AOS along with the I-140 downgrade for my son, who's aging out by March of 2022, with priority date of December 2013, who is on H4 COS from change of status from H4 to F1 for my son, while AOS pending. Will that have any issues?
I am not expecting issues for this one. We will, as the things get anything, as of now though, we have not seen any issues for people like your son to get the F1 approval in United States. We have not seen it as of now. But since, we strongly recommend everybody who is listening to these, if you are in United States, if you are on a non-immigrant visa, if you have not got the green card, we strongly recommend that you come to this show every week. We'll keep on updating. Certain things we cannot answer it then and there itself. For example, Ramesh Ghatamanini's son, what I can say right now is that based on the USCIS interpretation right now, we have not seen a single denial yet, because a person has filed an adjustment of status when they are under 21, when they applied for a change of status to H-4 to F1, we have not seen a denial. But if there is any update that pops up, we will inform you later on.
Okay. Fair enough, sir. Ramesh, sir, if you're watching this, then please keep following our show to get any further updates on this. But today we're all out of time. Rahul Garu, thank you so much for your like mindful of information and matter. So thank you so much for sharing and informing all of us of all of the different things that are going on, as well as the different questions that people call in with. We really appreciate your time, sir. Thank you so much for being on the show.
Thank you.
All right, and for all our viewers Sunday, please same time next week we'll see you on our show with the talk show with the expert Sunday. So thank you so much. Tune back in and watch our show every week to stay on top of immigration updates. Thank you and have a wonderful day. Bye.
ఎక్స్చేంజ్ 8,000 రూపాయల బ్యాలెన్స్ మ్యామ్.
ఇవ్వనక్కర్లేదమ్మా, 8,000 మీకే వస్తాయి.
ఎస్ మ్యామ్, మేము కేవలం హాల్మార్క్ 916 గోల్డ్నే అమ్ముతాం. ఇంకా మీకు దొరికింది 100% ఎక్స్చేంజ్ వాల్యూ.
క్వాలిటీ, ఇది మలబార్ ప్రామిస్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్, 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్.